this?
No, not when you're in court. Right now, technically, we're not in court, so
You know,
I guess it's fine.
look at you all bright-eyed and bushy-tailed. How you been?
Me?
Yeah, you looking good,
I've been
girl.
good. How about you? I haven't seen you in a while, and I was happy about that.
Yeah, I gotta pop in once in a while.
I guess.
I wanna ask you a question.
Are you talking to me, Miss Bearhart?
Yeah,
Okay, what's up?
okay. About the whole drug court thing. I mean, I know you're a nice person and all that, but what if I'm a little scared of you?
You wouldn't be the first.
Yeah. I
So,
mean,
um, uh, did you apply for drug court?
I come got interviewed.
Well, that's good. Okay. I know it can be scary, but it's all in for good reasons and just because I do truly care about the people in my treatment court. I care about the people in front of me in court.
You just yelled at me about my knees.
Yeah, because you're in court.
I wasn't in court, I'm in jail.
Miss Bearhart, you are still appearing in court. This is a court hearing.
I didn't know that it was on the record. You didn't say on the record.
I know, but still, I mean, I would think that you would want to present
Oh, I'm
in a
representing.
different
Don't worry
manner.
about that.
So, all right, I have Mr. Flisky. I'm going to send you in, okay?
I think you.
Hess, can you hear me?
Yes.
Oh, to clarify, sir, an earlier question, the traffic tickets are going to be dismissed and read in.
Okay, thank you.
We will go on the record in the matters 25 CF 110, 25 TR 630 and 631, State of Wisconsin versus Daniel Hess. The state appears through Assistant District Attorney Kevin, yeah,
Just a logistic matter. I believe your microphone is off.
thank you. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel in person. Mr. Hess appears by video conferencing in custody. I believe he's in Dodge Correctional Facility. We're set today in this matter for a plea and sentencing. Mr. Hess, you appear by video conferencing from Dodge. Do you understand that you do have a right to be here in person?
Yes, I do.
And are you asking the court to allow you to enter a plea and be sentenced by video conferencing?
Yes.
All right. Do you understand that at any time you have any questions or concerns and you need to speak with your attorney, I will send him into Zoom and give you a confidential breakout session, okay?
Okay, thank you.
If at any time you can't hear something or see something, please let me know so that I can make sure that you've heard and you understand everything, all right?
Yes.
All right, okay. So what is the agreement that's been reached, Mr. Flisky?
Thank you, Your Honor. The parties have reached an agreement here for Mr. Hess to plead to count one of the complaint. Count two, as I understand it, will be dismissed as a matter of law. A joint recommendation between the parties for statutory minimums on sentencing, which for an OWI of this category would be no less than 4 years of initial confinement.
All right. And that's the agreement that you have reached, Mr. Hess?
Yes.
Okay. All right. So, Mr. Hess, I have in front of me a plea questionnaire waiver of rights form. Did your attorney go over that document with you?
Yes, he did.
Did he essentially read it to you word for word?
Yes.
And did you understand everything completely?
Yes, Your Honor.
If you did not understand something, did you ask your attorney to explain it?
Yes, I did.
And he did so.
Yes.
You are pleading guilty to one count of operating a motor vehicle while under the influence, 10th and subsequent offense. Is that correct?
Yes, Your Honor.
And you did not sign this document because you are currently incarcerated and Mr. Feliski is here, and it's sometimes difficult with prison, mail, etc. But did you give him or are you giving the court a statement on the record that if you had the ability to sign it, you would?
Yes.
You are pleading guilty again to the OWI 10th offense and, well, under the influence. You're 57 years old. You have 12 years of schooling. You can read, write, you understand the English language. Is that correct?
Yes, Your Honor.
Mr. Feliski, did you thoroughly go over this document with Mr. Hess?
I did, Your Honor.
Did you essentially read it word for word?
I did, Your Honor.
And at the time, do you believe he understood everything?
I did, Your Honor.
Did you fully explain to him what the state would need to prove guilt beyond a reasonable doubt for an OWI 10th and subsequent?
I did, Your Honor.
Did you go over with him the mandatory minimums as well as the maximum possible penalties he may face?
I did, Your Honor.
You are, and Mr. Hess, you are not receiving any treatment for any mental health illnesses or disorders and no alcohol, drugs, or medications. Is that correct?
Yes, Your Honor.
Do you also understand that here the state would have to prove for count 1, operating a motor vehicle while under the influence, 10th and subsequent offense on or around August 4th, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, a 10th countable offense. Do you understand what the state would have to prove?
Yes, Your Honor.
You understand this is a Class E felony, and upon conviction, you face a fine of not more than $50,000 or imprisonment of not more than 15 years or both, and that because of the nature and the gravity of this offense, and that you have been, you have 9 or less countable, or 9 countable offenses, and this would be 10th or subsequent offense, that the court shall impose a bifurcated sentence of a confinement portion of not less than 4 years of initial confinement. Do you understand that?
Yes, Your Honor.
Do you understand that there is an agreement here that's been reached in which the parties are going to recommend to the court the minimum maximum penalty, the minimum, confinement that is required and mandated?
Yes, Your Honor.
Do you understand that as judge, I'm not bound to follow that minimum mandatory requirement, and I could sentence you all the way up to the maximum if I thought it was appropriate? Do you understand that?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes, I did.
In particular, there is a section called the probable cause section in which it basically says what happened and why you were charged with the crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant in this county and this state?
Yes, Your Honor.
Are you admitting here today that it is your 10th or subsequent countable offense?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Mr. Feliski, may the court use the probable cause section of the criminal complaint along with the statements made by Mr. Hess to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Mr. Hess, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing,
Yes, Your Honor.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes, he has.
Has he answered all of your questions?
This rapid-fire questioning may sound repetitive, but it's intentional. The judge is building a bulletproof record, confirming competence, understanding, and voluntariness. If this case is ever appealed, these answers are the court's shield.
Yes.
Has he looked at this matter thoroughly?
Yes, he has.
Has he discussed with you the discovery and the evidence in this case?
Yes, Your Honor.
Has he discussed with you whether or not you have a defense or a lack of defense in this case?
Yes, he has.
Have you discussed with him any facts and any and all facts that you know to exist about this case?
Yes, Your Honor.
Have you discussed with him any of your ideas as it relates to this case?
Yes.
Are you satisfied with his services?
Yes, I am.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count 1, OWI 10th or more, a class E felony, how do you wish to plead?
I wish to plead guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
My apologies, Your Honor. I might have missed it. So the joint recommend, I'm just filling in my apologies. So joint recommendation is 4 years initial confinement, no agreement on extended supervision, just the confinement.
I believe it was the statutory minimums.
Okay, just wanted to clarify, Your Honor. Thank you, Judge. This is a case where dispatch received a call about an unconscious driver that was passed out behind the wheel of his vehicle. I believe the joint recommendation is appropriate in the sense, given the defendant first and foremost is taking responsibilities for his actions. While this is a serious level offense, I believe the sentence will provide Mr. Hess the opportunity to take advantage of whatever programming is available in the jail to help tackle that alcohol abuse problem that seems to be plaguing him. But it would also accomplish the goal of general and specific deterrence. First, by specifically deterring Mr. Hess as he has reached the highest level of felony OWIs in Wisconsin. From here on out, any subsequent conviction will carry a mandatory minimum of 4 years of initial confinement.
I'm going to stop you. He's reached that, but what is his actual number?
This is number 10, Your Honor.
This is actually number 10.
Yes,
All right. Now you may continue slower.
thank you, Your Honor. But secondly, we also want to generally deter the public here. Driving under the influence will be taken seriously, and these offenses can carry a mandatory minimum sentence. The need to protect the public will also be accomplished here since the defendant will be confined for initial confinement of a period of 4 years. The ultimate goal here
Notice how the judge slows the prosecutor down here. This isn't impatience, it's precision. At this level, details matter. The court isn't sentencing a number, it's sentencing a pattern.
should still also be to reduce the chance of recidivism. As such, I would ask the court to adopt the joint recommendation. Thank you.
Mr. Flisky, argument, please.
Thank you, Your Honor. When I first began representing Mr. Hess, he was very upfront about the need to take accountability and responsibility for this matter. The fact that he was willing to do that from the outset on such a serious case, Your Honor, tells me that he very much understands that this was a significant and severe error on his part. He has regretted it deeply. He's indicated that to me essentially every time that I've spoken with him. He deeply, deeply regrets the decision that he made. He's made no excuses for it. To me, I don't anticipate that in any statement he would give to the court, he would make excuses then either. He acknowledges that he did wrong here. This is something that never should have happened. It happened, but he is here today before the court to take responsibility and accountability for his actions. I would note very thankfully in the fact pattern here in the complaint, it seems that there wasn't any injuries nor any damage to any property. This was not the result of a crash, either with another vehicle or a rollover in a ditch. Mr. Hess was found unconscious in his vehicle, and later investigation indicated that he was operating it while intoxicated. I bring that up, Your Honor, because I think here the mandatory minimums are appropriate given the nature and circumstances of this case. I would note that the last conviction Mr. Hess had for this type of offense was back in 2016. He's indicated to me that for a significant period of time, he was sober. He was doing well in the community. It's my understanding that for the most part, actually, he's been a resident of Montana rather than Wisconsin these past several years. He advised that when he moved back to the area, he had some difficulties in adjusting to probation here. And what I mean by that, Your Honor, is that it sounds like he had several agents who were appointed and then were either transferred, quit, somehow removed.
We've had a lot of change.
There's been a lot of change, Your Honor. And I think that having that in the short period of time that Mr. Hess was in here, unfortunately, may have negatively contributed to the situation. I don't say that, Your Honor, to, again, excuse Mr. Hess's actions. They're not excusable, but simply to provide some context here that there were some supports that Mr. Hess could have received that unfortunately he wasn't able to get access to. I think overall that this is an appropriate agreement. I certainly think the public is protected. Mr. Hess was revoked on these. Of course.
You guys both like to speak a lot fast.
Of course, Your Honor. Mr. Hess was revoked on this matter. He is currently in custody at Dodge, so he will remain in custody in there for some time, to my understanding.
Is it 4 years?
I believe so, Your Honor. I think that the statutory minimums here, what's recommended is appropriate. Again, given the nature of the offense here, this is certainly a very serious matter, but looking to the lack of injuries, looking to the lack of damage, looking to Mr. Hess's willingness to be upfront before the court and say, I did wrong, I will take my punishment, I will move forward, and I will improve and not have this situation happen again. I think overall this would be an appropriate agreement. I will lastly add, Your Honor, that Mr. Hess is advised once he does get out of custody, he does intend to relocate back to Montana. That's where his family, friends, support group are located. It sounds like that he was doing quite well when he was in Montana. He advised that he was employed with the company True North Steel. I may be misremembering our most recent conversation regarding them, but it sounds like that may be an opportunity available to him should he return to Montana as he is planning. I think the programming available in the jail for Mr. Hess, in prison, excuse me, for Mr. Hess will be sufficient to address the ongoing substance use issues that he has been dealing with, and will hopefully provide a framework for him to avoid ever having this happen again, and to never appear before this court, or frankly, any other court for this offense, or any offense ever again. Overall, Your Honor, I think that the agreement here between the parties is appropriate. I would ask the court to follow it. Thank you.
Thank you. Mr. Hess, can you please, if you would like to provide a statement to me, this is your only opportunity to do so. You don't have to, but again, it's your only opportunity to let me know anything you want me to know.
The other thing I'd like to state is you said I'm very, very happy that no one was harmed. That the only person that is truly affected is myself. My intent was never to harm anyone, and I would like the courts to understand that. So that's basically all I'd like to add. Thank you.
Thank you. Mr. Hess, I believe that it's never anybody's intent to harm anyone when they operate a motor vehicle while under the influence and something happens. No one wants that to happen. Everybody, quite honestly, anyone who drives behind the wheel while intoxicated believes, I'm not drunk. I can handle it. I'm just going 6 blocks. I'm not going that far. And then something tragic happens. The court has to first look at the seriousness of this violation. This is an OWI 10th. This is very serious. This is so serious that 9 other times wasn't enough for you to understand and to learn not to get behind the wheel. 9 other times. Your blood alcohol content was 0.323. 0.323. It's 0.08 in Wisconsin to be above the legal limit. 0.323. That's extremely high. And you were passed out in front of the wheel. Not just sleeping. There's a difference. So this is extremely serious, and thank God, thank all of the spirits, and thank everything that we can that no one was injured or hurt, and that includes you, because we've had other situations in which it has been extremely different, and we've had to bury people or had people in wheelchairs for the rest of their lives. So this at least had that positive where nothing happened. I have to look at you and your criminal record. I do take into account, and I see that it has been 10 years, give or take, since your last OWI. However, the 9th still wasn't enough. It wasn't enough to say, all right, Mr. Hess, I'm not getting behind the wheel. I'm not going to put anyone at risk, and that includes me. I'll walk home, even if it's 10 miles, instead of getting behind the wheel and driving. And I have to look at the community and protecting the public interest here and the public in general. Because this is an OWI, it's serious in and of itself. But then when you tack on, this is the 10th, it makes it extremely more serious because you can only tell someone so long and so many times, stop, stop, stop. Hopefully this was it. Hopefully this was the last time and you're not going to do it again. And hopefully no one ever becomes injured or killed while you're behind the wheel. With regards to this matter, you do have 4 years and some change to sit from your revocation. You were revoked off of extended supervision. I was toying with what to do if I follow the recommendation. But you have 4 years, and if the court follows the recommendation, that's 8, because the court, this is definitely a consecutive sentence. So I will follow the recommendation, 4 years of initial confinement consecutive to any and all sentences you are serving. You are not eligible for any earned release programming. No earned release programming. 5 years of extended supervision. You are not eligible for earned release programming while on extended supervision, because if you are.
This is where the sentence stops being about time and becomes about control. No alcohol, no bars, continuous monitoring, permanent license revocation. This isn't just punishment. It's the system saying, we cannot trust you behind the wheel again.
Are revoked off of extended supervision and you still haven't learned your lesson, shame on you, shame on me. So with that, on extended supervision, absolutely no alcohol, no possession, no use, no bars, taverns, liquor stores, casinos, no establishments that have the primary purpose for the sale or service of alcohol, no beer tents, nothing that would serve alcohol. Regular alcohol testing, regular, that means you will have regular testing, and quite honestly, when you are released from extended supervision, the court will order that you must have a buddy bracelet or similar, meaning that you are wearing a bracelet that continuously tests your blood alcohol 24/7 for the first year while you are off of extended supervision, and then regular alcohol testing. Definitely absolute sobriety, AODA assessment and all follow through, mental health assessment and follow through. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. With regards to the OWI 10th, this is a doozy. The court is ordering $8,446 in fines and fees plus a $10 blood draw fee. Revoking your driver's license permanently. No chance of getting another driver's license. The court is ordering you provide your DNA. The prison will make sure that they have it. This is not something you can have it expunged because it is so serious. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, but the court will issue a warrant. You could sit an additional 6 months in jail. Mr. Vila, what is the court missing?
I don't think you're missing anything, Your Honor, not from my perspective.
Mr. Felisky.
Nothing further. Thank you.
All right, thank you. Then we are adjourned.